What did the judge say about XRP? Which emails is the judge talking about? Is the lawsuit over? If you want to learn all about it, keep watching this video to find out more, so that you don't miss out on an excellent opportunity to win a giveaway of 25 XRP tokens at the end of this month. Hey guys, welcome back to XRP Daily, the best spot for your daily dose of everything XRP and cryptocurrency. In today's video, we will talk about XRP's future. So be sure to stay focused, as you don't want to miss out on this. If you are new to the channel, be sure to subscribe to the channel and turn on post notifications by hitting the bell so you never miss any of our uploads, and also enter our giveaway. The SEC filed the lawsuit in the U.S. against Ripple on 22 December 2020, alleging that its offers and sales of XRP violated the registration requirements of Sections 5A and C of the Securities Act. Ripple claimed that the SEC did not provide a specific warning that its offering and selling XRP implicated federal securities laws, depriving it of fair notice, according to a memorandum of law supporting the SEC's motion to strike Ripple's defense. The SEC stated in the memo that in 2012, before it sold a single XRP, Ripple's lawyers told Ripple that the sale of XRP could be deemed a sale of securities under the federal securities laws. It added that from 2013 through 2020, Ripple sold XRP for nearly $1.4 billion, and almost all of its revenues came from the sales of XRP to public and private investors. Given the historical advice Ripple had received since 2012, questions from market participants on the obvious question of whether Ripple's offers and sales of XRP required registration under the securities laws and the SEC's formal investigation, defendants were aware for many years that the securities laws could apply. The SEC must surrender to Ripple an email with a draft of former Director William Hinman's speech on whether Ether is security as part of an ongoing lawsuit the regulatory agency filed against a crypto startup, a judge ruled Thursday. The SEC sued Ripple and members of its leadership at the end of 2020 on charges the company sold and continues to sell the XRP cryptocurrency in violation of federal securities law. The agency and Ripple have been involved in a protracted back and forth over what sort of documents must be made available through the discovery process. Ripple has sought several documents detailing internal SEC communications and policies. SEC attorneys claim these documents contain staffer deliberations and are protected against discovery. Magistrate Judge Sarah Netburn of the Southern District of New York Federal Court ruled some of these documents are protected, but ordered the regulator to turn over others, including the email with Hinman's speech and some notes from meetings between SEC staffers' third parties that are not Ripple. We're pleased with the court's order, which grants Ripple access to important documents that the SEC was withholding. We will continue to defend this case aggressively, and we remain optimistic that resolution of this case will provide much-needed clarity to the industry, Ripple General Counsel Stu Alderodi said. An email of the draft of a 2018 speech by Hinman, former Director of Corporation Finance, is included in the list of documents to be surrendered. Hinman gave the speech in June 2018, telling the audience at a conference that in his view, Ether was not a security. The speech was seen as pivotal for the crypto industry, given the first 60 million Ether was sold to raise funds for the Ethereum Foundation. Ether is now commonly seen as a commodity in the U.S., with the Commodity Futures Trading Commission overseeing derivatives products based on the cryptocurrency. Hinman's speech reflected his views, he said at the time, a point the judge referenced on Thursday in her ruling. The privilege does not protect the personal views of agency employees unless they bear on the formulation or exercise of policy-oriented judgment, the judge said in a 23-page ruling. Accordingly, emails concerning the speech or draft versions are neither pre-decisional nor deliberative agency documents entitled to protection. While the email with the draft speech must be turned over, a separate email sent by the Office of the Chief Counsel for Corporation Finance the day before his speech does not need to be turned over, the judge wrote. The documents related to SEC staff's legal analysis of XRP contain the SEC's staff preliminary views during the Division of Enforcement's investigation into XRP and did not present a recommendation to the SEC, she said. These documents were prepared for the investigation into XRP and therefore qualify as the kind of pre-decisional and deliberative legal analysis the deliberative process privilege protects. The SEC also does not have to turn over notes from meetings between SEC staffers and Ripple, as well as interagency discussions, the judge ruled. Ripple has won a major procedural victory in its battle with the SEC. A federal judge ruled on Thursday. The judge has ruled that the agency cannot claim that emails related to a landmark 2018 speech about Ethereum are privileged documents. A former top SEC official delivered the speech in question, William Hinman. He told an audience that Ethereum was not a security because it was sufficiently decentralized. That speech is also central to the lawsuit. The SEC alleges that Ripple and its top executives knew that the blockchain's digital currency, XRP, was a security that had to be registered with the agency, yet it was sold to the public. As part of its legal strategy, Ripple has sought to obtain evidence on how Hinman decided Ethereum was not a security. This evidence could help the company refute the SEC's claims about the nature of XRP. Thursday is a larger batch of documents. For example, notes from SEC crypto expert Valerie Sesepanik are discussed. The notes contain various SEC deliberations. Also included are emails in which Hinman and others discussed a draft of the Ethereum speech. The SEC had argued that the documents fell under its so-called privilege. Privilege is a legal term that means that a party does not have to share it with its opponent in a lawsuit. The SEC invoked the attorney-client privilege and other privileges designed to shield government agencies in certain situations. U.S. Magistrate Judge Sarah Netburn agreed with the SEC on certain documents. However, she rejected the agency's argument for more than a dozen batches of other documents. In the case of the emails about Hinman's speech, Netburn concluded that the privilege did not apply because the speech was his personal views, not those of the agency. Here's the most important part of the decision. Hinman and the SEC admit agency employees discussed his speech, but it turns out that this speech was only incidental to the actual policymaking due to TIGU 312F.3D at 80. Thus, there was no essential link in the SEC's Ether consultation process, Grand Cent PSHIP 166F.3D at 482. As a result, emails about the speech or drafts do not have pre-decision agency documents, nor are there any deliberative documents that are entitled to protection. Netburn's decision will give Ripple new ammunition in its legal opposition. The decision will also benefit public opinion. Here, many think that the SEC has unfairly cracked down on the company in the crypto industry. Nevertheless, the ruling is only a procedural one. It has little bearing on the larger issue in the case. This issue revolves around whether XRP is a security or not. Overall, Ripple sought access to 14 entries and 3 additional documents. The SEC is further ordered to review its privilege log and produce, in full or in part, any documents previously withheld based on the privilege that would be inconsistent with this order, Judge Netburn wrote. The case likely to be made in court in the SEC versus Ripple lawsuit is that SEC officials, namely ex-SEC Commissioner William Hinman, have given a leg up on Ethereum. His 2018 speech stating that Ether is not a security has triggered a bullish move that positioned ETH as the second most valuable crypto asset in aggregate market capitalization. Judge Sarah Netburn has recently given a mixed ruling regarding the deliberative process privilege issue, as she declared some documents were not privileged but kept others as is. As part of that decision, the SEC was ordered to hand over the email regarding William Hinman's 2018 speech. The email was sent to 63 people. The judge also accepted the SEC's claim the speech was only Hinman's personal opinion and was not intended as policy. For years, Ripple's XRP was placed in number 2 after Bitcoin and has steadily lost its standing since then, with other digital assets taking their place in the ranking. Despite all this, Ripple Labs continues to work with payments companies to launch financial products and services using the Ripple blockchain and XRP. It's working with governments in several developing countries to introduce central bank digital currencies and cross-border remittance services. Well, guys, that's all we have for you today. What are your thoughts on this? Get involved and let us know in the comments down below. If you guys like this video, then be sure to give this video a big thumbs up. Also, if you don't want to miss out on any new future videos, then be sure to click on the subscribe button and turn on the notification under this video so that you're notified the next time we upload a video on the latest XRP and cryptocurrency news. Until the next video comes out, you can watch our other videos about XRP or other cryptocurrencies. Thank you for watching, and we will see you again in the next video. Goodbye.